I may have settled innumerable petitions, I may alter a paragraph, I may dictate a paragraph instead of rewriting the whole thing. But I have never done. And there are lawyers in Supreme Court who follow that practice. There's no big issue about it. It has a very positive side to it. If I refuse to draft the petition, I am helping some junior colleague to do his work. If I take that over, then I will look for some AOR to sign the petition for 2,000 rupees. So that's not a very healthy practice, but I must admit it does happen. So if you are designated senior advocate, there is absolutely no issue. You can practice any day in Supreme Court. But then you have to see whether you will get the work or not. That is one danger of designation. That you can't, strictly speaking, talk to client directly. You can't file papers. You can't draft the petitions, and others don't brief you. Then where do you go? Then the malpractices begin. So you have all the choices, but adopt the good practices, not the malpractices. Apart from this, the other thing is, if you are practicing in Delhi, which we don't have that advantage outside Delhi, that young lawyers do not have to give up their practices in their respective courts, in say High Court or in Consumer Court or in trial court, any trial court, because in Delhi every lawyer is a Supreme Court lawyer. I knew a lawyer who was only a notary public. His wife was also notary public. So his card said Advocate Supreme Court of India. His wife's card said Advocate High Court of Delhi. So I said, Ama to equal treatment rakho. Why is she Advocate of High Court when both of are doing only stamping the documents? So, but this is on a serious note. Youngsters amongst us who are thinking of shifting, this is your saving window. That while you are looking for work in the Supreme Court or waiting for the briefings, you can start working in the say Delhi High Court, in the Consumer Court, etc. So that is one way to survive in Delhi. Because since the idea is practice in Delhi, practice in Supreme Court of India, Supreme Court is in Delhi, and Delhi is an expensive city. So if you shift there, you must know that say my monthly expense is 50,000 rupees, where will this 50,000 come from? Either you must have some source or in your savings, or somebody regularly sending you the matters, or you start working in other courts also. That's the best, possible solution. Because if you start, go there after practice of say 5, 7, 10 years, immediately you may or may not get work. But eventually people do get work. Never be disappointed, but be ready for hardship, say for 1 year or 2 years at the least. In the beginning, even when the work comes, it is so useless. For example, I will give you my direct experience. I just shifted to Supreme Court in 97. Kalpesh Bhai has been my friend, Justice Kalpesh Javeri, from his father's time. He was on the panel of ST. So he sent me 6 cases for filing SLPs. 6 cases. You would think that this is great bonanza. You are just starting the practice and somebody has sent you 6 cases. All the 6 cases were cases from MA City, where people had died in accidents with the ST buses. And in case of death, they were given the compensation in those days of 1 to 2 lakhs. If there is in Supreme Court, say by 97, 98, then the cases in first court must have arisen some 10 years back. So 1 to 2 lakhs. Now, when you stand up in Supreme Court with your SLP, man has died, he is given 2 lakhs, and you want to argue a case, they, sir, this is too much, they look at you, where have you come from? So all the 6 were dismissed. So be ready for that eventuality. You have to survive the failures. I could not blame Supreme Court for dismissing those 6 matters. The man has died. Is it too much to give him 2 lakhs of rupees? But then in the beginning, this is the kind of work you would get. So first thing, if you are thinking of shifting there, examine whether you can be an AOR or not. Second thing, examine whether you have a network of friends who will help you with the matters from other courts, high courts, etc. Thirdly, think of whether you can work in some other court in Delhi or not, because Delhi can be very expensive. If you rent an ordinary flat, you will need 1,000 rupees a day at the least. So just remember that. I was a student in my Ahmedabad days and did not have enough money. So once we went there in a very posh hotel. I was required to take somebody, so we went there. So the waiter comes and he sprays this dry clean tablecloth, fresh. Those days dry cleaning cost 2 rupees for 1 piece of cloth. So the moment he sprays the cloth, my friend says, so if you go to Delhi, remember that 50,000-60,000 rupees per month you will need for one person to survive. I am not talking of lavish life, I am not talking of luxurious life, I am talking of regular middle class life. These are practical aspects. So, I am sure you are hungry, and I see people waiting for their lunch, and I have only so much food to offer. So if you have any questions, I'll be more than happy to answer. Yeah. All?
Orders must be reasoning.
With reasoning, yeah.
Yes.
Speaking orders.
I come across many cases and orders of the Supreme Court where only one word, rejected.
Yeah.
They never gives.
Yeah.
So, how it can be adapted?
Yes.
In this matter, we understand, my lord. Jethmalani's judgment is 500 pages. This Salve's judgment is also in a big books, my lord. But here, ordinary petitions are given only rejected. So, how it can be challenged?
I understand. I'll answer. There are 2 things. One, Supreme Court has said that reasons are required to be given so that Superior Court can see whether the subordinate court has rightly reasoned the issue or not. But as far as we are concerned, there is no higher court. Therefore, you can say it is a judicial arrogance that we are the Supreme Court. Who will look at our reasoning? But you still have a point, because the litigant must also be satisfied that his matter has been dismissed for valid reasons. We had a famous writer who died some years back, Neeraj Chaudhary. He was a great supporter and champion of British Empire, and he thought that was one great thing that happened to India. When there were stories of Prince Charles having extramarital relationships, Neeraj Chaudhary reasoned that why are these British people clamoring so much about extramarital relations? What is the use of being prince if you can't have a extramarital relation also? રજવાડા હોવાનો અર્થ શું છે? તો આ બધા રજવાડા છે, જ્યુડિશિયલ રજવાડા છે, કારણો પૂછવા નહીં.
Hello. My respected sir, my question is this, that you have rightly said that the Supreme Court has widest jurisdiction, can talk any matter, can take any matter, can decide any matter. And it is also said that it is the interpretation of the Constitution is the prime duty of the Supreme Court of India. In the Constitution, there is provision for amendment of Constitution. If any amendment is made by the legislature or parliament, the jurisdiction of the Supreme Court is to see whether this legislation or amendment has been made as per the provision of the Constitution, or to go that whether it is against the Constitution basic structure. First thing. Second thing is this. The first line is this. There is principle of natural justice. In the principle of natural justice, these are two things. One cannot be judge of his thought. But in this case, which you are referring, which is has been discussed by the Constitution bench of this judicial amendment.
Yes, sir, gentlemen. Therefore, what is the question? Because we are other one waiting. So,
Not
what is the
just one.
question?
In that case, the principle of natural justice was also not followed. What I mean to say.
That's right. See, you do have a point, but I don't agree with you that principles of natural justice were not followed. We also have a doctrine of necessity, under which sometimes a court is compelled to decide a certain case. So since Supreme Court is the final arbiter of all legal and constitutional disputes in India, it had to decide. There is no choice. As far as your first part of your question is concerned, how court can decide regarding its own appointment, etc., there are very serious disputes about it. I have my own reservation also, but that will not answer any question, because Supreme Court has assumed that power. You can't help it. If you read this judgment, there are 5 opinions of 5 different judges running into more than 400 printed pages. It is a judgment which I would call masterpiece of rationalization. Therefore, the Constitution says the President shall appoint judges of the Supreme Court of India. The Constitution doesn't say Supreme Court shall appoint. But for all practical purposes, they have acquired that power in the name of basic structure of Constitution of India. So today the basic structure has come to mean this, that our power has to be perpetuated. I don't know whether it's the right thing or wrong thing, but it has happened. The question that you have is a question which many people have, but as a lawyer we must accept that what the Supreme Court says is final and not what we say. Thank you.
Hello. I have a question with regard to writ petitions. We all know that in writ petition, the Limitation Act is not applicable. We can file any time. Of course, it's a reasonable time. We just... my question is, then when we file a review against, in decision which is given in writ petition, whether limitation act applicable or not. Because ultimately, when we file a writ petition, we not use a civil procedure code. That is my question.
I know, you see, under the High Court rules and Supreme Court rules, there is a time limit for review. That is one. For example, in Supreme Court, there is a 30-day limit. So you can't go to civil procedure as such. Secondly, you have to do everything within reasonable time. You can't come file a review after 5 years and say there is no provision for limitation. Thirdly, you are right. For example, filing of writ petition, there is no time limit as such, though normally the standards of civil law are adopted. There is an old English judgment which says that suppose I file a petition 5 years after the cause of action has arisen, and if the question is why the petition was not filed for 5 years, so in explaining the delay, a judge says, this is English judge, that when you say there is a delay of 5 years, you do not mean mere lapse of time. So there is a lapse of time of 5 years, which only means that earth has gone round the sun 5 times. Now the question is, how is that relevant to my case? Whether earth has gone round the sun 5 times or 10 times. Therefore, delay is something that accrues from your knowledge, from the accrual of cause of action. And therefore, limitation or no limitation, by and large there are limitations. If there is no limitation, then reasonable time is the limitation. I hope I have answered your question.
Let me answer Rakesh's query. Rakesh asked that when petition itself does not contemplate any limitation, why should there be insistence of limitation for filing review petition? Now, if you examine the provisions of Constitution, there is no express conferment of review jurisdiction in High Court. It is merely a simple recognition of inherent power. In Supreme Court, there is an express conferment of review jurisdiction. Article 137 specifically provides. And there is a logic why there is a specific provision for Supreme Court for review. Because Supreme Court was comparatively a new institution. High Court was already existing. When the Constitution was framed, all High Courts were there. They had all inherent power. Being a court of record, it has all powers unless specifically excluded by a statute. So review was considered to be an inherent jurisdiction. You will not find in any book from how does High Court derive review jurisdiction. So I am in agreement with your say that when High Court rules or anything does not provide for limitation, there cannot be insistence of filing a review petition within 30 days because this is inherent power. And very interestingly, in Allahabad, for writ of certiorari, High Court rules provided limitation of 90 days. And Supreme Court in that case, Chandra Bhushan's case, probably AR 1967, page 1272, Supreme Court said that High Court rules cannot provide any limitation for filing a petition, and that rule was held to be ultra vires. So once there is no limitation for filing a petition, there cannot be a limitation for review, but you have to act in a reasonable manner. You have to approach the court within a reasonable time. Thank you.
Thank you, sir.
I'll add. Article 137, which provides for review. 137 says, review of judgments or orders by the Supreme Court, subject to the provisions of any law made by Parliament or any rules made under Article 145 by the Supreme Court. Under Article 145, the Supreme Court shall have a power to review any judgment pronounced or order or made by it. Therefore, Parliament can make the law, Supreme Court has made the rules, and as Asim Bhai rightly said, there is inherent power which flows from its being court of record. Court of record, this is one more facet of court of record, that it can review its own judgments also. But again, the question was regarding limitation. That issue remains, it is governed by the law or rules or by the discretion.
Sir, last question I want to ask. Most of the lifespan is passed in the Supreme Court. Most of the lifespan is. So now we get the experience from you. And you also suggest that anyone want to shift to the Supreme Court. What is the significant aptitude required to being a lawyer of the Supreme Court? You see, 25,000 lawyers is here in Ahmedabad, only 1,000 or 2,000 practicing here. So what is the main 2-3 points I want in the nutshell, that what is the significant, whether confident or knowledge, out of two, what is the important factor? Whether confident or knowledge, that I wanted.
One of our senior advocates, who is one of our leading advocates here, I will not name him. He doesn't in fact, he doesn't come to Supreme Court, he doesn't like it. But once he came, and he was very well prepared, and his matter was called out.